started on our subject matter, let me briefly introduce myself. My name's Tim Forshey. That is Irish, not French. Do not pronounce it Forshey, and we'll be just fine today. I'm a practicing attorney in the state of Arizona. I've been practicing law for about 32 years. I'm a judge pro tem for the last 16 years in the cities of Scottsdale and El Mirage, Arizona. I was also on the Maricopa County Sheriff's Armed Posse for about 11 years, and I was a prosecutor in downstate Illinois for 2 years before I moved to Arizona. So I have arrested people, prosecuted people, defended people, and sentenced people. That's a brief introduction about me and my background. Let's talk about Title II firearms. What do we mean when we talk about Title II firearms? People get confused about this because the term Class III firearms has become synonymous with Title II, but the proper nomenclature, which I will violate myself in just a moment, I'm sure, is Title I firearms and Title II firearms. We're talking about Title I and Title II of the 1968 Gun Control Act. Title I is all of your quote-unquote normal firearms, all breech-loaded smokeless powder guns manufactured since 1898. Excluded from that, of course, would be Title II firearms. Title II firearms, also commonly referred to as Class III firearms, would include machine guns, short-barreled rifles, short-barreled shotguns, destructive devices such as grenade launchers, suppressors, which we're going to talk quite a bit about today, and then the last category, which is causes a great deal of confusion, any other weapons. Again, Class III is a misnomer. People say Class III firearms. Class III is actually a designation that a dealer has bestowed upon them by ATF. A Type 1 dealer is your normal, regular gun dealer. A Type 3 dealer has what's called an SOT, a special occupation tax, that allows them to sell, manufacture, and possess Title II firearms. So we're going to probably end up using the term Title II and Class III interchangeably, so just be prepared for that. Again, why would anybody need a Type II firearm? And I guess the first response to that is need. Who said anything about need? We don't have no stinking need. It's America. So in all seriousness, short-barreled rifles and short-barreled shotguns are far easier to handle and shoot with one hand than conventionally linked shotguns and rifles. They're also easier to resist disarm attempts. If I've got a gun that's 12 inches long versus a gun that's 20 inches long, it's much easier to pull that gun in, and it gives less leverage to somebody who's trying to take the gun away from me. Also, much easier to conceal. Obviously, you probably don't normally conceal a rifle or a shotgun, but in a certain situation, that could be life-altering, life-saving. Also, of course, much easier to conceal and travel with the firearm. If it folds down or it goes into a smaller case, it's easier to be more innocuous, put it in your rear seat, put it in your trunk, etc. Suppressors, as I said, we're going to talk quite a bit about suppressors. They need to be destigmatized. Right now, suppressors have this image that you're evil if you have a suppressor. Politically, they're demonized. They're also something that a lot of people just don't understand too much. So let's talk about them. You'll hear people call them suppressors. You'll hear people call them silencers. You'll hear the cool kids call them cans. My favorite term for them is something that's much simpler and, again, more innocuous: mufflers. That's all they are. When they were invented by Hiram Maxim, basically he had a muffler company that he turned into a silencer company. There's exactly like the muffler on your vehicle. They should be destigmatized. All they are is a safety device. That's all they are. Let's talk about the National Firearms Act. We talk about the NFA. This is actually a 1934 federal gun control law. It was the first federal gun control legislation passed in 1934. It was actually originally aimed at taking away almost all guns, including even handguns. FDR and the Congress decided in about 1933 that they needed to start fighting the war on crime. Does that ring any bells with anybody these days? It worked well enough to get Al Capone arrested and convicted in 1931, so the way they decided to attack this was through taxation. As you probably all know, Al Capone never went to prison for murder or robbery or bootlegging. He went to prison for tax evasion. And a light bulb went off with some federal prosecutors, and they decided maybe we can attack these criminals that are running around the country shooting everybody up with machine guns by taxing those guns into oblivion. So that's what they did. In 1934, in response to those organized crime gangs like the Dillinger Gang, the Barrow Gang, that of course Bonnie and Clyde, Pretty Boy Floyd's Kansas City Massacre, that was a machine gun massacre. Everybody in the whole country's panties were in a gigantic wad over all this wanton destruction and death being meted out by these crazy people. There were a lot of Thompson submachine guns and Browning automatic rifles that had been stolen from National Guard armories all across the country, and these were particularly feared features of these problems. So Congress passed the 1934 National Firearms Act in response, frankly, because they could. Handguns were dropped from the act. During committee, there was enough resistance to that they did take handguns out of the act. But all the prior types of weapons that we mentioned a few moments ago are included to this very day, almost 80 years later, still in the act. Over 80 years later, still in the act. Interestingly, short-barreled rifles currently are rifles that have a barrel less than 16 inches in length. Short-barreled shotguns are shotguns that have a barrel less than 18 inches in length. Even though we all know the labyrinth that are federal laws in this country, especially gun laws, why would they have to distinguish 2 inches difference between rifles and shotguns? A couple of years ago, I actually met somebody that knew the answer to that question. It turns out that they both were originally set at 18 inches. But following the Korean War, when we started importing surplus M1 carbines back for civilian sale in the U.S., somebody wise realized that the barrels on M1 carbines were about 16.5 inches long, and they violated the National Firearms Act. So believe it or not, Congress amended the NFA and allowed rifles with barrels of 16 inches to still be legally owned without the special registration required by the state. You'll also hear people discussing the difference between Form 4s and Form 1s. This is basically about what's called your tax stamp. Once you've paid your tax to the federal government, sent in the proper application forms to be able to take possession of your Class 3 item, you're going to get a tax stamp, and that's going to be affixed to an ATF Form 4 or an ATF Form 1. A Form 4 is the more conventional of the two. That's for the vast majority of Title II firearms. A Form 1 is required when you have manufactured your own firearm. And people get a little bit bent out of shape when we talk about manufacturing that. That simply in ATF terminology means you've changed it from a Title I firearm to a Title II firearm. It could be as easy as taking the upper off of your AR-15 and replacing it with an upper that has a barrel of less than 16 inches. As far as the federal government's concerned, you've now manufactured a new firearm. So it's important that you take that into consideration as well. Suppressors, again, what I said earlier, let's call them mufflers, are essentially the ultimate in hearing protection. You don't need earmuffs for most rounds shooting with a suppressor. They just take care of the problem right there. The vast majority of Veterans Administration disability claims in this country from our veterans are for hearing loss. I've heard it as high as 90%. Why? Why is that? Why can't we spend the extra $300 or $400 per soldier or sailor and issue our men and women at arms suppressors? It's cheap and appropriate, and it would solve a lot of issues with regard to our tax money being spent on medical claims. Suppressors are fantastic tools for teaching new shooters how to shoot. They reduce recoil approximately 30 to 40%. They reduce blast 80 to 90%, noise 80 to 90%. It makes the entire shooting experience far less intimidating, far less frightening, far more enjoyable. It's the best way to get new shooters involved in the sport. It vastly reduces or eliminates both short and long-term hearing loss. Okay? But let's talk about it from a practical aspect, though. Nobody wants you to be deaf in your 50s because of your exposure to gunfire, and that's true for all of us, of course. But let's be a bit more pragmatic about the now instead of the then. Do you realize that most home invasions involve a crew of miscreants, not just one person, but up to 3 or 4, multiple offenders? Let's say you defended your home, you heard the first invader, you shot them with a non-suppressed firearm, and they're down. Guess what? You're now deaf. Your ears are screeching and ringing, and you are basically out of the fight in terms of your hearing. Can you hear your children's cries for help down the hallway? Can you hear the accomplices, the other people moving about your house? Can you hear the person moving the refrigerator to block the door? You can't hear any of those sorts of things. Your inability to hear in your home at 3 in the morning could end up leading to you and your family's death. This is an extremely important consideration when we talk about suppressors for home defense. Out-of-home defensive uses of suppressors, in a word, no. The use of Class 3 firearms outside of the home for what I will call defensive purposes will look to cops, prosecutors, and juries to be more offensive than defensive. You're not Charles Bronson or Tony Soprano, and you want to make sure that the authorities know that you know that. So don't be screwing the suppressor onto your pistol if there's some guy shooting up the parking lot of the Walmart. It's not going to look good in hindsight. In your own home, however, after the intruders have breached what I hope are your considerable defenses in that home, it's a totally different situation. When we talk about breaching your considerable defenses, let's make sure before we talk about your home defense firearm that you considered such things as reinforcing all of your bolt locks and hinges to your doors and windows, that you have a good dog that will alert you to those intruders, that you have motion sensor lights on the exterior of your home, that you have an alarm system that hopefully is monitored off-site, that you have a video surveillance and recording system that again is loaded to the cloud and recorded off-site, that you perhaps place laminate shatter-resistant film on all of your exterior windows, that you have a safe room with bolts, etc. If you do all of those things, folks, it's very, very rarely that you'd ever even need to think about using your firearm because the bad guys will give up. This is, after all, not another episode of Mission Impossible. Tom Cruise is not lowering into your bedroom from cables. I think you're probably going to be okay if you spend some time and money reinforcing your home in the first place. Perhaps the ultimate home defense weapon, sorry, President Biden, but it turns out it's actually an AR-15. Most experts would tell you that an AR-15 with proper ammunition is the ultimate home defense weapon. A lot of people say, wait, that's a rifle. that will over-penetrate. That'll leave your home, it'll enter your neighbor's home, it's going to cause all kinds of ancillary damage. And the secret here is this particular cartridge. It was originally designed as a varmint cartridge. I know it was used in Vietnam, and thank you to all you veterans that are watching this. But prior to that, when it was called the 222 Remington, it was designed as a varmint round. What that means is it's a very tiny bullet going very fast. If you stick to those tiny bullets, if you stick to 55 or 50 or 45 or 40 grain bullets going 3,000 plus feet per second, that bullet is so small, going so fast that when it strikes wallboard, it begins to disintegrate immediately. I myself have done this test, and I've read many other people that have duplicated this test. If you fire a 9mm handgun round into layers of sheetrock versus a 223 round with a 55 grain bullet into those same layers of sheetrock, you'll find that the 9mm handgun round actually penetrates further and deeper than the 223 round. So you can sort of, again, with proper ammunition selection, you can sort of take that issue off the table. Again, 62 grain military rounds, the typical green tip rounds that the military has issued, that has a penetrator steel core inside of it. Do not ever fire that inside of a house. That will go through your house and your neighbor's house. Heavier target style bullets, the 75, 77, 80, 95 grain bullets that people use for long distance competitions with AR-15s. Again, very bad choice for home defense. What is the legality of such a setup? As an example, here we have a short barreled rifle. This is an AR-15 chambered in 5.56 or 223. This one's actually chambered in 5.56. This has a 12-inch barrel, and it also, as you can see, has a suppressor attached to it. This actually, when you collapse the stock and takes the suppressor off, again, the entire setup is only about 22 inches long. That is very, very handy, easy to store, easy to conceal. You can put it in your trunk or the back seat of your car quite easily. Very easy to move around a home with one hand. You obviously can still hold this with one hand and maneuver it. If somebody is trying to take it away from me, I can pull it in this way. They don't have much leverage. In fact, if you think about it, they don't have any more leverage than they would if I had a handgun. So it's actually, there are a lot of pluses about this. Now, just so everybody's clear, this particular setup actually requires 2 tack stamps. One, because the barrel of the gun is less than 16 inches, so I need a tack stamp on a Form 1, since I manufactured the gun technically, for the SBR, the short barrel rifle itself, and of course a second for the suppressor itself. It's good if you go ahead and get the whole setup at once and submit the paperwork one time and one time only. It just saves a lot of time. Again, a very, very appropriate home defense firearm. It's set up with a white light. It's set up with a red dot sight. It has a sling on it. Again, a sling, folks, to a long gun is the same as a holster to a handgun. You need a sling. There could be a situation during that home invasion situation where you need both hands to tend to your spouse, to tend to your child, to deal with the police officers. You want to make sure you keep control of the firearm, keeping it on your person, but freeing up your hands. That's going to require a sling. Here we have a perhaps more compact and more easily maneuverable Class 3 firearm, if you will. This is a Glock 19X. This is just a Title I gun. You can purchase this gun at most any gun store in this country. All you'd have to do is purchase an aftermarket threaded barrel. Or if you do, I believe Glock is now manufacturing a couple of different versions of threaded barrels. If you can get it from the factory, great. So this part of the gun is a Title I. This is a Title II Class 3 suppressor. This is an Innovative Arms Lex 9mm suppressor. It simply threads onto the barrel of the Glock, and as everybody can tell, that is an empty firearm. This threads right onto the barrel of the Glock. You attach a Surefire flashlight. Again, a very appropriate home defense firearm. This is 18 rounds of 9mm, suppressed, so hearing safe. With a flashlight, again, there's far worse setups to protect your home with this. Now, make sure you understand with regard to any of these laws that I'm giving you information pertaining to U.S. federal law as interpreted through the state of Arizona. These are all legal in the state of Arizona if you follow the procedures that we're about to get into, but they may not be legal in your home state, okay? Your mileage may vary. Make sure you check your local and state laws, and it's always a good idea to consult with a firearms knowledgeable, gun-savvy attorney in your area who's familiar with your laws. Now, interestingly, there are actually 3 different ways that you can legally acquire Title II weapons, okay? The first one is the old one that everybody used to do back in the old days. It is, in fact, easiest and cheapest, but there's big problems with it, and that is you can purchase it as an individual. Me, Tim Forshey, goes into a store, and I register the item to me as an individual. Now, there's a couple of big problems with this. First of all, we have this situation that we call accidental felonies. Let's say your friend, your family member finds themselves in possession, even what the law calls constructive possession of your Class 3 item when you're absent, okay? If that were to happen, both they and you could be charged with very serious federal felony charges. Let's just say, for instance, that you come home from the range on a hot day in Arizona. It's 115 degrees. You and your 3 best friends were shooting your short-barreled rifle with the suppressor at the range. You come home, you're hot, you're sweaty. You can't even bear the thought of unloading your truck right now. You decide to go in and take a shower and grab a beer. While you're in the shower, your well-meaning spouse with no ill intention whatsoever decides to borrow your truck to go to the Costco to buy a 100-pound bag of dog food because that won't fit into her Lexus. So while you're in the shower, she takes your truck and she goes to the store. Sadly, on the way to the store, she's involved in a crash, clearly not her fault, and God forbid she suffers a broken ankle. While they're transporting her to the hospital by ambulance and people can't reach you because you're taking too long of a shower that day, they decide to impound the vehicle, which they're required to do before they can tow it. And when they impound it and search it, 2 police officers in the back seat inside of your gun bag notice you have an SBR with a suppressor attached to it. You and your wife could both be headed to federal prison. Unfortunately, that's a sad truth. That's just how this works. Additional to that, you could wind up in prison a couple of other ways as well. Well, you wouldn't. But let's not forget that it's a sad fact of life that life ends. The Grim Reaper comes for us all. When you die, all of your Title I individually owned items are no problem whatsoever. Those are out in the safe, and your spouse or your children have complete access to those, no problem. Your Title II firearms, however, if you have suppressors, if you have short-barreled rifles, if you're fortunate enough to own a machine gun legally, your survivors now have a real problem. They're forced to work with the ATF before they can even get legal authority to sell or dispose of those items. They're often completely ignorant of that fact. They may not even know what those items are until somebody else tells them. They try to sell them at a gun store. They find out it's a Title II firearm. It could be a real problem for everybody. I always try to practice law, certainly with regard to firearms laws, in the same way as a smart spouse, and that is that it's always better to stay out of trouble than it is to try to get out of trouble. Individual ownership is setting you up to wind up in trouble. So I would tend to agree with most experts that that's not the best way to own a Title II firearm. The second way that you can own a Title II firearm is by setting up a corporation and then establishing what's called corporate ownership of the items. You can legally co-own Class 3 items if they are owned by a corporation with you as the president and your protected others, people that you completely trust, listed as officers of that corporation. Problems with that method? Well, first of all, some of you probably know this, it's way more expensive to set up a corporation than it is to establish a trust, which is what we're going to talk about next. You must name a statutory agent. Usually that's an attorney. That person has to accept any court documents that are served on the corporation. That can be expensive and an ongoing expense each year to pay that stat agent. Most states also require that annual papers have to be filed, maintained, and updated with the Corporation Commission, which have to be calendared and funded every year. That's expensive, time-consuming, one more thing to clutter your calendar and your day with. Lastly, the corporation and your ownership involvement of that corporation are both a matter of public record. No confidentiality is possible here. The transparency of Class 3 firearm ownership is never a good thing. It can make you a target of burglars as well as public scrutiny and criticism. It's also always discoverable in any civil litigation. Again, there's no way to make it confidential if you establish a corporation. The third and most popular, and frankly the only smart way to do it, is to establish what's called an NFA Trust, or a National Firearms Trust. We basically, you would set this up where you're the grantor trustee, and then you can name as many co-trustee, what the ATF calls responsible persons, as you'd like, usually at no additional cost. If a co-trustee is in possession of your Class 3 items, they have the same exact right to do that as you do. So there's no problem. If your wife is the co-trustee on your trust and she gets into that car crash, well, you've got a broken ankle to worry about, but no legal problems with regard to the guns to worry about. When you die, your surviving co-trustees, spouse, children, have the same continued right of ownership, including the right to sell if they so desire, as you had when you were alive. Once and done. Once you set up the trust, you don't have to spend any more time or money worrying about it. There's no tending required. It always is easily amendable, usually for free, if a death or a divorce or an address relocation occurs. Very quick and easy to fix it. It is far cheaper and far quicker to establish than a corporation, and again, completely confidential. There's no public record whatsoever of your trust. You can enjoy all the benefits of Class 3 firearms as quickly and cheaply as possible by establishing an NFA Trust prior to shopping for your first Class 3 item. Your shopping cart is now ready for your purchase, if you will. You have your trust ready to go. You go to the store where you plan to buy your first Class 3 item, you hand them the trust, and they start the paperwork process right then. Unfortunately, a lot of people find all this out later after they've tried to buy the suppressor or the short-barreled rifle. Then they have to leave the store. Sometimes they'll go ahead and pay for it, but they can't take possession and they can't start the paperwork process until they get the trust established. It doesn't take long to set up a trust. If the attorney knows what they're doing, it's usually 24 to 48 hour turnaround. It's something that almost always can be done without an in-person meeting, but it does need to be taken care of. The process is easy. Let's go ahead and cover how that works now. Now, a very legitimate question that I get from people all the time, not just about NFA trusts, but about a lot of the work that attorneys do, is why would I pay an attorney to do something when I can get it online for a hell of a lot less money? Very valid point. If you go to an attorney to have a will drafted, you're probably looking at a couple $1,000s for a will. You can go get a will kit at most any Hallmark store for $80. Why would you do that? The analogy I've come up with, which I think is a good analogy, is let's assume that your toilet is leaking some evening when you get home from work. You're not an idiot. I'm quite sure that with Google and YouTube that you can almost undoubtedly figure out how to fix your toilet. You're going to make 4 trips to Home Depot. Your toilet's going to smell like feces all night. Your wife's going to be mad. You're not going to get any sleep. And if it's still leaking tomorrow, you're going to call a plumber and be even more frustrated than you were last night. So there's risk involved with doing it yourself. Anytime it's something that a professional makes money to do it as a living, and you decide to do it on your own, there's risk involved. When we're talking about the legalities of Class 3 firearms ownership, where you're looking at possibly 15 years in federal prison if you screw something up, to me, that's something I'm not going to scrimp and try to save a couple $100s on. Let's let a professional do it right. Don't forget, if an attorney does it and it's wrong, you can sue them for malpractice. You have that additional benefit that you don't possibly have if you do it on your own. So yes, you can find online NFA trusts quite a bit cheaper than our company will provide them, probably quite a bit cheaper than any law firm will provide them, but there are downside risks to that. If you decide you wish to proceed, you're going to contact us. We will then send you the 3-page NFA questionnaire for you to complete and return to us. We will then turn that into your trust and get it right back to you. You'll have a chance to edit that. If we misspelled anything, missed anything, you'll communicate with us by email. We'll make any edits appropriate. Once it's in final form, you're going to down print that. You're going to then take that hard copy to get it notarized. You and any and all co-trustees are going to get the document notarized. Then you're going to date it with the date of the last notarization. Take the original with you when you go to your dealer to buy your first Class 3 item. They're going to then get fingerprints, photographs, and another form figured out for you while you're there, and then they'll mail everything off. Now we're just waiting for the federal government to do their job. Right now that seems to be taking somewhere between 3 and 9 months. The rumor is they're going to hire more civilian employees in the NFA section of ATF, and that hopefully will speed that up even more. Probably the biggest reason that people don't buy these items is because who wants to spend the money to buy it and then not be able to walk out of the store with it? So these procedures that we discussed will speed that up and have all the benefits of NFA Trust ownership that we've already discussed. So now that you see how easy it is to actually acquire and own your Class 3 firearm, there's really no reason not to do it. It's safer, it's a lot more fun, it makes the whole recreational experience better for everybody involved, and I think that you'll agree once you try it. So good luck, and let us know if you have any questions.